Good morning, this is your Kelso Report for Monday, August 13th. I'm your host, Clark Kelso. Well, we begin with the Ninth Circuit. A question about which side is this party on. Now, as a general rule, federal courts have broad authority to look beyond the pleadings and arrange or realign the parties according to their real sides in the dispute. The question presented in Scott's Company v. Seeds was how far beyond the pleadings the trial court could look. And the Ninth Circuit held that when a federal court evaluates realigning the parties in a case, it may not consider claims made in a different case. In particular, the trial court here wanted to examine the claims being made by the defendants against the plaintiff in a series of lawsuits filed in state court to help determine what the primary dispute was between the parties. The Ninth Circuit held that this was error. Instead, the trial court should limit its inquiry of what constitutes the primary dispute to the primary purpose of the federal case before it. Don't go looking for other causes of action in other cases. Next, an attorney's fees case, a rather important one I would imagine. The award of attorney's fees to prevailing plaintiffs in class action litigation is a matter subject to the district court's equitable powers. Among other things, a district court may reduce or eliminate fees entirely if class counsel has committed ethical violations in the course of its representation. In Rodriguez v. Disner, the Ninth Circuit affirmed the district court's decision to deny attorneys' fees entirely to counsel for the named plaintiffs in a major class action that settled just before trial for almost $50 million. The problem was that counsel had entered into various incentive agreements with 5 of the named plaintiffs, which authorized counsel to apply to the court for an attorney fee award in exchange for counsel agreeing to seek incentive compensation for each client in amounts between $10,000 and $75,000, depending on the value of the overall settlement. Well, the Ninth Circuit concluded that the district court reasonably found the incentive agreements created an inherent conflict of interest from day one between the named clients and other class members. It was a conflict built into the retainer agreement, and that agreement was not disclosed to the court until counsel sought its fees. Accordingly, it was a knowing, willful, and concealed conflict of interest, and that constituted egregious conduct warranting forfeiture of the entire attorney fee award. A big loss for plaintiff's counsel. Finally, a labor law case, an important one out of Los Angeles. Over the last several years, layoffs in the Los Angeles school district have resulted in a disproportionate percentage of teachers at certain schools losing their jobs because of the seniority rules that govern the layoff process. At some schools where there were a lot of new teachers, as many as 2/3 of the teachers were laid off. A group of enterprising students sued the district, requesting that it provide a different mechanism for conducting layoffs that would mitigate the impact of the seniority system at certain schools. The suit was based on the theory that the students were being denied an equal right to educational opportunity because of the seniority-based layoffs. The teachers' union was permitted to intervene in the action to protect its rights. The students in the district, after negotiations, entered into a consent decree that modified the seniority-based layoff system over the objection of the teachers' union. And after conducting a fairness hearing, the Superior Court entered judgment on that consent decree. A split bench of the Second District reversed in Reed v. United Teachers Los Angeles. According to the majority's interpretation of the U.S. Supreme Court's leading decision in W.R. Grace v. Rubber Works, 1983 case, entering the consent decree, which abrogated contractual rights provided for in the collective bargaining agreement over the union's objection, without having a full hearing on the merits, violated the due process rights of the union. As the court noted, permitting such a result would undermine the federal labor policy that parties to a collective bargaining agreement must have reasonable assurances that their contract will be honored. The dissenting judge took the position that the fairness hearing constituted sufficient due process to protect the union's interests, and that a hearing on the merits was therefore unnecessary. It seems to me that the majority has the better of it in this case. The union's contractual rights should not so easily be set aside with a mere consent decree by others that receives the blessing of the court without having a hearing on the merits where the underlying claim can be tested. I'm guessing that the California Supreme Court will leave this decision alone. And that's it for today's Kelso Report. Have a great day in the law.